Item 4, agenda adjustments. Yes. I will move to motion, vote Mark's contract in and approve it. There is a recommended action to add Mark's contract onto tonight's agenda. Yes. Discussion? Yes. I'm not going to keep pulling through the same thing, so I'm just going to make this short. I'll try it short. So again, just keep in mind, Amy, you stated back on November 22nd of 2024 that you had no intentions on renewing Mark's contract. So I don't know, what your thoughts were back then. I don't know why you said that, but we all know that we have had a lot of improvement in our school district, and they were caused and done by Mark. I mean, look at our graduates from just this year that graduated. We had over 101 students, and a lot of them, they got awards for achievement. They have received scholarships. Now, if it wasn't for Mark bringing in companies to sponsor these scholarships, our students wouldn't have had that. You guys are not looking at what he has done and how he has improved. You got to look at the facts that are in front of you. I don't know how many times I have said that. You can't look at whatever your personal vendetta is. I keep saying, if you have something in mind, go to Mark and say, hey, Mark, can we do this for Bridgeport? Can we bring this in? You don't need Amy's approval. Because just like that gentleman said, we, the board, are Mark's boss. So you don't need nobody's approval to go and talk to Mark. If he says something you don't like, then go to him and say, Mark, when I was so upset with him, when I thought he was being rude to Flinnoia, I went to Mark, and then when he explained himself, I said, well, why didn't you say that to Flinnoia? He said, well, she didn't ask. Again, communication, people. You have to communicate with each other. It doesn't go one person or the other. It takes two to communicate. So you got to communicate to have that relationship. Any other discussion? So there is a motion to add Mark's contract, to vote on Mark's contract tonight, to add to the agenda. Wrong. Mr. Sawatsky?
Yes.
Mr. Lang? Mrs. Bieszke? Yes. Ms. Irby?
No.
Ms. Castillo?
No.
Mrs. Breamsey?
No.
Ms. Morales? No. We have 3 yeses and 4 opposed. Motion has failed. No agenda adjustment. Item number 5. For the motion to go into closed session, meeting under Section 81H of the Michigan Open Meeting Act to discuss and consider legal opinion from Sherman Law Firm, which is exempt from disclosure under state law due to attorney-client privilege. Is there a second? Comment. Any discussion?
The subject of 31AA is in fact a public matter
that does not require going into closed session, so I would ask why. Mr. Whelton already has the advice of Truant in this matter, so that it is already a matter of public record. And I'm asking why we need to go into closed session to discuss an opinion that most likely is already, from a disclosure perspective, shared with all their districts within the state. So why are we going into closed session? There's nothing that an attorney can tell us tonight that would be proprietary in nature to this school district that would precipitate the need to go into closed session to discuss the matter, as I understand it. Is that correct, Mr. Whelton? In your opinion? Yes, sir, that is correct. It only took me about 10 minutes to do the necessary research to find, in fact, that it wasn't necessary, that this matter does not rise to the occasion of anything that would require attorney-client privilege.
Well, at the Michigan Council for School Attorneys that took place in October, they did recommend for districts to give legal advice.
Getting legal advice is one thing. Going into closed session is something quite different. And there's been no demonstration of the advice that would be given to this board would be, in fact, any degree of proprietary nature, and not something that's already, well, if we indicated to the superintendent.
It actually changed today. I'm sorry, I don't mean to interrupt. It actually changed today just a few hours ago as well. Sure. And Truant is here to give their opinion, and in order for them to give that opinion, it is to be in closed session.
Well, I hope you understand that if you do this and the attorney does, in fact, go into closed session, he's putting himself at risk as well for going into closed session where, in fact, it's not necessary. So I will let you see that you choose. Just understand where that you're aware.
Well, hearing none, Robin, the vote to go into closed session.
Mr. Sawachty?
So no.
Mr. Lang?
Oh,
Mrs. Bieszke?
No.
Ms. Irby?
Yes.
Mrs. File? Mrs. Breezy?
Yes.
Ms. Morales?
Yes. More of our district monies were. Yeah, but one base class covered every cost.
We have 3 no votes and 4 yes votes.
So that does not pass. We do not go into closed session at this time. It has to be 2/3 to go into closed session. So not going to closed session, we are going to I have a motion for an amendment to the agenda. Actually, we can go ahead. I have a motion to do a 5-minute recess. Could I have a second?
For what reason? No reason for a 5-minute recess. We're not here that long.
It's seconded. Latoya seconded. And now there is John. So I made wait a second. Yep. And then I discussed.
Okay. Ms. Morales?
Yes.
Ms. Bieszke?
No.
Mr. Sawachty? Ms. Irby? Ms. Castillo?
Yes.
Mr. Lang? Ms. Breezy? Okay, we have 4 yes and 3 opposed.
Motion has passed. So 6:30. We'll go ahead for 5 minutes. 6:35. We'll go right. Clock since it's there, yeah. 6:30. 6:35. Go ahead and start back up. 5-minute recess. First one. No. Amendment to the agenda. So we're making an amendment to the agenda. Flinnoia, you can go ahead and read that. But we have to. We're going to make the, actually, yeah, go ahead, Flinnoia, you can go ahead and start. So, actually, yeah, this is an amendment to the agenda, and we're adding the resolution. I'm sorry, this is. Let's see that. Resolution, Bridgeport Supporting Community School District. Whereas concerns have been raised about the district superintendent, Mark Whelton. And whereas, following an initial review of the concerns raised about Superintendent Whelton and the board's determination that further investigation of those concerns is warranted, the board determines that Superintendent Whelton shall be placed on paid without loss of salary or benefits, and shall suspend all performance of his authorized responsibilities and duties as the district superintendent pending further investigation and issuance of a written notice regarding same absent further board action. And whereas it is in the best interest of the district to afford maximum procedural safeguards to Superintendent Whelton, while preserving the board's flexibility to exercise its discretion and authority to move forward as swiftly and fairly as possible to resolve this matter. And whereas it is necessary during the pendency of the investigation of this matter that an acting superintendent be appointed to serve of the district superintendent of schools until further board action. And whereas this board believes that it is necessary, appropriate, and in the best interest of the district to hire an independent investigator to investigate this matter on behalf of the board. Now, therefore, it be resolved that 1. Superintendent Whelton is hereby placed on paid administrative leave pending the district's investigation of this matter effective November 21st, 2025. The board president or his designee shall provide a copy of this resolution along with a notice of paid administrative leave to Superintendent Whelton on November 21st, 2025. 2. Superintendent Whelton shall immediately cease performance of his responsibilities and duties as the district superintendent without loss of salary or benefits. Including but not limited to communications directly or indirectly with district employees and students, and is not to be on district property without approval of the president or his designee. Absent further board action other than at an open meeting of the board. 3. Dr. Flinnoia Hall is hereby appointed as a district acting superintendent and shall perform all of the responsibilities and duties of superintendent of school and further board action. 4. All resolutions or part of resolutions that conflict with this resolution I will send.
I think that was the first issue.
I'm done.
Doesn't matter.
So that is an amendment to be added to this meeting tonight as read. Is there a second? Second. Discussion? Yeah, why is this the first that we've heard about it? Again, we're supposed to be a board of whole, and this is the first time I've heard about it. So, the board is discussing. For the board, discuss it. Does anyone have, so we're going to follow, does anyone have a aim that stop you to Mark answering, asking the question? Does anyone have a breath? Okay, I'm going to ask, why is it two? Why is it the first time that us four, me, I know, well, I'm sure your little butt wipers there has heard it. Yes, Eric sure hasn't. Why is it the first time we've heard about it? And second, on what grounds do you have the right to do that? Or did he walked out, didn't reread it, and even the attorney knows we didn't go into post section. There you go. How is that legal advice? What?
The person goes outside here.
And the remember what they said. Bordeaux. Yes. Do you want to reread that portion where the reason? So, I just answered my question. So because Tammy wants to, I so young, read that reason. Yes, why am I just finding out? And then where's the proof? I mean, you then, sir, want to do investigation, but there's nothing ever that came in front of us stating that Mark has done anything. So come on, explain yourself. So then why would you be objective to any type of investigation if nothing has gone? So, you got to have proof. Right. Okay, so what has the proof? Why? So this now the attorney body had top forward now because I mean you can only go into closed session for an attorney. And as he told you, yeah, as he told you, did you talk to him? Yes, the attorney client too. So, yeah. Yep. So, any other board discussion? He's Tanny, so then why don't you wait, Tammy, until there's a investigation? We are not privy. It is not in here as to what was presented. And we cannot send Joe. Who was it? No, they too. Mark will be notified, but we can't be notified. Why can't I be notified? Hold on, please, guys, please. Please, stay quiet. Please. So, Amy, who did these complaints go to?
The lawyer.
So these people contacted our attorney and made these complaints.
So I can't answer that. I don't.
Okay, then what? Come up. He can't. He cannot talk. He can answer if they actually called him and complained. And who gave him? They must have got his number from someone. So he's not them. So again, he can answer if he received these phone calls from these people.
I don't know what he's received.
And that's we're reading. We can't tell their names, but he can tell us. I worked for a trade for 25 years. I know what they cannot do. And I know what people are not supposed to be doing when they don't have a P number.
Yeah.
Like you try to.
He just found it right now.
So I'm asking that attorney if he received phone calls from people complaining. And why is it the first time we've heard about it? You're supposed to be our attorney. So I'm asking him to come up and explain.
You are the no sidebar.
Sit down.
Yes, please.
Mike,
So our legal counsel, would you consider answering Tim's questions, please?
First of all, the superintendent has due process rights. Second of all, if complaints are received, they should be investigated by boards. Those are two very clear things. In order to do a fact-finding investigation, you need to be able to investigate these matters and provide the superintendent with due process and do it quickly and promptly. That's what's occurring here. If the board decides that they don't want to take action, that's the board's decision. And the complaints will just be the complaints and will stay. If the board decides today that they do want to take action, they can investigate this matter, clear it quickly, and move forward. Otherwise, if they don't, the complaints will stay, and then obviously they have to deal with potential legal exposure. That's their options. So at this point, Mr. Whelton has an attorney, and if those complaints, if the board approves an investigator, his legal counsel will be contacted, and he will get due process. So it's up to the board at this point.
Okay, but my question is, was it the public that called you and made the complaints, or was it a board member?
I can only say that I received complaints because, frankly, I need to be able to, if we do get to that point and you approve an investigator, it needs to be investigated by a third party and independent investigator. I work for the board. I do not investigate a superintendent. So that's not my job. That's not what I do. And reason we have a third party come in to do it is because we want somebody that has no connection to this to look into the complaints and move quickly and clear the matter. So if the board decides today they want to investigate it, they can. If the board decides they don't want to investigate it, that's their choice. But to actually have those complaints sit and wait month after month, that's exposure that they have to be concerned about.
So after the investigation, do we get copies of this? That's what I was just saying.
You will, wait a minute, because let me make this clear. Mr. Whelton has due process rights. If an investigator looks into it and determines that there's no findings, then you move forward and he issues you the report, the third party, to the board. That's how that works. You have to let somebody that has no connection to this investigate this. So there's no claim of bias or prejudice or whatever. So that's in order to ensure there's a fair process that can be an option to take by the board. The board can decide if they want. There's a number of ways the board can handle this, but the complaints have been received. So that's where things stand. And you got to give Mr. Whelton due process. And if you don't give him due process, there'll always be things like this lingering. So I don't know what else to tell you other than that. So
Okay, I have a question for you. You came here to talk about 31AA.
I said I came to talk about Section 181H of the Open Meetings Act. I didn't say 31AA. I have legal opinions.
Sphere.
It may say that, but I came to speak about Section 81H, legal opinion. So I don't know how it was labeled, but I had either way, it was not accepted. So you have to have 2/3 votes. We didn't have it, so you don't go into closed session. The board has to vote, and it has to be 5 votes.
Well, right here on the agenda, it says 31AA opinion.
I open to walk up and drop back.
Well, all I can say is that this juncture,
So are you having that this board met in order to address an item that was on closed session agenda that was not accurate?
there would likely have to be a motion to amend the agenda that wasn't brought in place at the time. But there's a motion on the floor right now.
I understand what's on the floor. It just seems to be a coincidence that we have an open meeting to talk about something, and then mysteriously after a 5-minute recess, this crops up.
Well,
Voice dropped off.
the board has a decision to make. I can't really say anything more than that at this point. It's up to the board to make a decision. They can maintain status quo, but they can take action on the motion on the floor. It's up to the board. Either way, Mr. Whelton deserves the process.
So now Robin is going to say the vote that we are going to adopt this resolution,
I just say.
and if Mark will be placed on, you'd have to read that. That's just the first couple of sentences.
No, but stay. Let them read. You'll work for that.
That would be,
You're about to.
so we're going to vote, it's going to be an admin, placed on admin leave, and if Flynn Hall would be interim. Go ahead. The red one wants very high to like
Okay. Mars doesn't have anything to hide.
7 run the district, not the lawyer. Remember that.
so.
Lawyer did on your recess?
So are we going to, we are going to vote now on the resolution for Superintendent Whelton to be placed on a paid administrative non-disciplinary leave, immediately cease performance, no change to benefits, and Dr. Flinnoia Hall. I appointed as acting superintendent. Birthday. So, Dr. Flint.
Hold on. Amy, I just have a question. Why can't there be an investigation going on while he's still doing his job? Because we don't even know if this is true or not. They're convicting him to saying he's guilty and they're taking him away from his.
So that would be a separate, that would be something separate. Right now, this is the one that's on the table.
Yeah.
So
why is Robin going there to the table though instead saying there's investigation but still have him do his job? So we're
gonna do just this one right now. So we're not in discussion. We just said we're taking the vote.
Oh, not the vote.
So
Pretty sure his funds is still on.
we were not in discussion. We were going to take the vote. So we're voting on that now.
Robin. Mr. Swatsky? Mr. Lane? No. Miss Bieszke? No. Miss Irby? Surprise. Miss Castillo?
Yes.
Miss Reamsey? Good. Go ahead.
Yes.
Horrible. Well, anyways, we have 3 votes no and 4 votes yes. Okay.
So the resolution for this motion has passed, taking immediate effect. But is another something to happen. Resolution, a motion, and swear.
Oh, no, like, oh,
And what the thing here?
wait, what's this word? What was I saying? Oh, my. I know you're better.
There's no feeling about the board. For motion by
Wonderful.
motion language, but the board meeting. The motion is to what?
Need prompt here.
Appoint Alan Telgenhof to handle a fact-finding investigation. The motion is on the floor for
Damn, I've seen this before, right?
No, but I can hear her. You guys, please.
appoint Alan Telgenhof to handle a
What was that name?
fact-finding investigation.
Alan, where?
So there's a motion on the table to appoint a fact-finding investigator.
I'm sorry, Amy. Please be quiet.
So here he appoint Alan Telgenhof to handle a fact-finding investigation. This is a third party. I'm sorry, hold up. Okay, so motion is on the table. Is there a second?
Amy, I couldn't hear the name of what until a second.
Alan Telgenhof.
Okay.
Is there a second?
Second.
Carmen, second. Discussion. Who recommended the third party?
Yeah.
District Legal Counsel.
What's the older date?
Third party.
Those people you did you to recess. Right? Thanks.
Does anyone have any objection to the lawyer? Again, and point. Right?
You guys should
Go ready.
keep thinking through that bottle again, yo. Like in the 5th or 6th place.
Stop. Aye.
This was
Former investment.
Okay. Okay. Alan Telgenhof is an attorney. He's a former prosecutor. He has been a former board member of North, and he does fact-finding investigations with school districts. He's got over 30 years of experience. He has been doing this with a number of school districts, and as I mentioned, he's a former prosecutor. You can find him on the website if you'd like to look up his credentials. I can spell his name out for you. It's Allen Telgenhof, Tlegенhof. That's not how it's spelled there. Telgenhof. It's spelled. Would you spell it again, please? Alan Telgenhof, Allen Telgenhof, Tlegенhof. Telgenhof.
Oh, the count,
Telgenhof.
he wasn't there.
He has been practicing for over 30 years, a former prosecutor, former board member, very familiar with school districts, very familiar with doing school district investigations throughout the state. So he has done this. He knows how school districts work, and he knows how to investigate matters, and he moves very quickly. So if you get him authorization today, he will start moving on this next week and try to get this moving so we can move forward. So either, again, it's about getting the matter to Mr. Whelton's attorney, getting this matter investigated, moving quickly, and hopefully this matter can be quickly resolved.
My attorney is not Jim or Jeff Tour. It's Eric Delapore, just so you're aware.
I'm very familiar with Eric Delapore. I still work with him as you know. I'm aware.
Okay, so what the attorney said is true. I do know who he's talking about, and he is a very honest man. So I was glad to hear that. I just had a hard time hearing the name when Latoya said it, so I had to have Amy repeat. So, you know, again, in case you guys don't know my history, I work for one of the very top big law firms here in Michigan. So he has a large law firm in Florida, Texas, and a couple other states. So that's why I'm familiar with the investigator that the attorney did suggest. So I do say, at least, you know, there at that point, yes, he is very honest investigator, and he doesn't tiptoe on anything, and it's hard to get anything over him. He's pretty quick thinking, pretty quick on his toes. So,
Any other discussion? That's closed.
We're being asked to move on something that, quite frankly, none of us has any idea from a scale standpoint if this even rises to the associated with the actions being taken by this board. I find that to be patently unfair. It lacks professionalism, the fact that it is spun on us in this manner, and the fact that we have had no prior notice of this information equally is a concern to me, because it would have been, had the closed session been in fact presented in the manner in which the attorney had suggested it should have been, much of this could have been resolved, and potentially we wouldn't be where we're at. So, in my mind, this does not rise. I have no reason to say we should appoint somebody. I have already said I don't believe that the resolution should have been passed, but obviously I'm not part of the Fab Four, so I just...
that's fair. Yeah. The top thing is, you know, and you had here for the closed section on 31A, the opinion. So we were misled. And that's the only thing, I know that's wrong. That is just wrong. So I am happy though when I heard, because of the situation, the investigator that he did get, and I do know who he is, and like I said, he's a very good investigator. He's on his toes, and if anybody thinks that they can lie to him and get away with it, he knows if you're lying to him or not.
Any other but
I'm just going to make a statement that I don't know that you, as a board, understand the irreparable harm that you're doing both in the district and at Superintendent.
So discussions on close. Go ahead, Robin. The vote now to hire, and I don't know if I'm saying it right. Boy, Tammy, you know him. Is that how it's said? Alan Telgenhof?
It's just like Tal and then Hulk.
Oh yeah. Okay. So to appoint Alan Telgenhof as the fact-finding investigator.
Mr. Sawatsky? Mr. Lang?
No.
Mrs. Bieszke?
Yes.
Miss Irby? Miss Irby? Miss Castillo?
Yeah.
Miss Breamsey? Miss Morales?
Yes.
We have 5 yes and 2 opposed.
The motion has passed for Mr. Allen to be placed as the fact-finding investigator. So as of tonight, we are now adjourned.
You'll never see signatures be done so fast in your life as you will right now. I promise. Yes, here's a pun. I'll say, here's a funny. Is it scary?